Just a few words of welcome. First, thank you to all the members of the judiciary, both on the panel, the distinguished members of the judiciary who are here, obviously our alumni, members of the bar, and members of the community, all of whom I gather have been affected, touched, or noted in some way the 40 years plus of work that Paul Trachtenberg has done to promote the aims and mission of social justice in New Jersey and throughout the nation. There are, I think, fewer examples or paradigms of what Rutgers Law School hopes to be of service and to the people of New Jersey and the nation than are represented by Paul Trachtenberg, who has devoted decades of his professional life to the interests of social justice, and in particular to the aim of having educational opportunity being given equally and fairly to all our school children. We have a wonderful program here that is honored by the presence and participation of a retired justice of the Supreme Court and an associate justice of the Supreme Court, including some of the most distinguished members of the public interest bar in New Jersey, and members of our own faculty, all of whom I think can bear witness to the contributions that Paul has made and is continuing to make to the people of New Jersey as we speak. So again, welcome everyone. I'm very glad that you came, and I wish you all a very enjoyable program.
My name is Larry LUSTBERG. I think this is a good program to do for two reasons. First of all, when you look at the panel, I'm pretty sure it explains the bump of 30 places in the U.S. News and World Report poll that Rutgers just got. But second, look, I mean, discussing education is, I think, what Paul would want us to be doing. There's a panel, there's a number of people afterwards who are going to say really nice things about Paul. But I think the way we can honor Paul the most is by having a really robust discussion of what's gone well, what's gone poorly, what the legacy of his work is, and how it affects all of us today and impacts the issues that are before courts and the public every day. I've had the honor to introduce Paul at various events. You can actually, if you want to, can make pretty much a full-time career out of introducing Paul or events honoring him. And so this is just another in that long tour. So we're going to start with this panel, and I'll introduce people as we go along. The first person to speak will be David Chiara. But David, I mean, I think what I would love for you to talk about is what was it like to take over the Education Law Center given the legacy of Paul Trachtenberg?
I had no idea what I was getting into when I took it over, and went into Marilyn's office, and no one was there. So part of taking over ELC at that time was that Marilyn, that the organization was in kind of dire straits, and Larry and Paul prevailed upon me to take it over. And lo and behold, all these years later, I'm still at it. It was at a very pivotal time in Abbott. This was 1990, beginning of 1996. We're going into the third year in which the Supreme Court had ordered, had thrown out QEA, the old funding formula that Paul and Larry and others had gotten the court to declare unconstitutional, and set a 3-year deadline for a new formula and for funding along the way. And that led to a formula that was enacted, proposed by Governor Whitman, and then we went back to the court. So it was really getting trial by fire, what I would say. We were just thrown into the middle of having to deal with what was a very contentious legal and political situation. I do want to say that the work was built upon the legacy that Paul left, and I want to just mention that, and then talk a little bit about, tick off a few legacies of Abbott that really are attributable to Paul and the foundational work that he and others did and that we've carried on. And that is the idea that Abbott was built on a case that really went beyond funding differentials to disparities in education between rich and poor. And back in the 80s, this was a daunting task to do, and something really that hadn't been done. We sort of take it for granted now, looking at schools serving poor communities and wealthy communities, but back then this was an enormous undertaking. And the record that was built in the Abbott trial in the 80s, and as chronicled by the Supreme Court in Abbott 2, still brings tears to my eyes. I mean, it was a tremendous record showing the disparities in educational opportunities between what children who entered school in our suburbs and who then entered school in Newark and Jersey City and other cities got. And that idea of the disparity in educational opportunity that went beyond just funding differences, dollar differentials, but dug into inputs, teachers, class size, teacher qualifications, support staff, AP courses, art and music, I could go on, and the outcomes differentials really laid the groundwork for a sea change in the way folks here in New Jersey thought about education and what to do about education, but really changed the national landscape. I can't underestimate the power that obviously led to Savage Inequalities being written. It was the inspiration for Jonathan Coles's book, inspiration for numerous writings, and the inspiration for advocacy in states across the country that's still going on today. I mean, the good news is, because of some of the successes in Abbott that are attributable to Paul and the groundwork that he laid in this case, we've eliminated a lot of that. We still have a ways to go. But when I go all across the country, some of those stark disparities that we had 30 years ago, that Paul and his colleagues laid out in the trial of Abbott, that led to the Abbott 2 decision, which is the foundation on which all the other decisions are based, you still see those. It actually finished the unfinished business of Rutgers, the Rutgers case, which dealt with dollar differences, but really got into differences in educational opportunities and qualities for kids across the country. As far as successes are concerned, Larry, I'll just pick there's so many impacts that the Abbott rulings have had on the way we approach public education today. I'll tick off a few. The first is that poor kids need more. The idea that the notion which we accept today in education circles, that if you're disadvantaged, if you come to school poor, the need to learn English, or with a disability, you need more resources in order to achieve a success in school. That is really attributable to the trial in Abbott, the rulings in Abbott 2, and then developed later on by rulings that Chief Justice Ports and Justice Stein and others were involved in. The other highlight is the notion that standards-based education, content standards and assessments, which we take for granted for now, defines the substantive level of education that all children should receive. That's a monumental change. Abbott had a big part in the 1997 decision of laying the groundwork for that thinking and that policy that swept the nation. And the notion that funding has to be linked to the cost of delivering standards-based education. These are all path-breaking accomplishments of Abbott. The other point is that there's accountability. The state has accountability not just for adequate funding, but for making sure that the funding gets to the classroom and actually benefits kids. That's an Abbott construct that you see now in influencing educational policy and litigation in court cases across the country. And the last, and I have to give a nod to Chief Justice Ports on this, is the preschool rulings. Still to this day, the first Supreme Court, High Court ruling in the United States to interpret the right to education as including the state's responsibility to provide at least at-risk children well-planned, high-quality preschool at age 3. And that is I can't even describe the kind of impact that ruling has had. So those are just a few of the highlights that I would bring out.
How about, not to be negative, but how about the lowlights? I mean, how about the areas where you feel that haven't quite succeeded, haven't quite fulfilled the legacy of Paul Trachtenberg? Are there any?
So, having worked at this not as long as Paul, but since 1996 and been through many rounds of Abbott, funding formulas, all of this, I think what I've come to know, come to the realization is that the business of school funding equity is always unfinished. It just is an unfinished, you never get there. And we see that today, right? No matter all the effort we put in, all the improvements we made, we now have a funding formula that the court approved in 2008 that is probably the strongest, most equitable way of calculating the cost of education and the funding needed for children. And yet now here, 8 years into the last budget of Governor Christie, we've got a huge unfunded portion of that formula. So you can have a great formula, but it's got to be funded from year to year. That is constant unfinished business that not just us lawyers and folks, but advocates, parents, concerned citizens have to be involved in. You also see it in preschool, which we got an enormous accomplishment in the school funding formula in 2008 that was required the expansion of the Abbott preschool program across the state to all poor communities and poor kids across the state in 5 years, still on the books, but as many of you in this room know, an unfinished business, and business that will remain unfinished for a while as we move into the next administration.
I will be very brief on my experience as Attorney General, in part because I was really involved in the Abbott litigation for a very short period of time, and in fact, I was unable to participate in the first Abbott case that came to the court after I was on the court for that reason. What I saw was the state attempting to make the case that education wasn't, a fine education was not about money. It was about good teachers. It was the kind of argument that the state made much later after I left the court, when Justice Lavecchia wrote the last two opinions. It disappeared in Abbott 5, essentially, and that was my first experience on the court with Abbott 5. So there was a kind of irony in seeing from the state's point of view the development of the argument that money isn't what this is about, seeing it change over time from Abbott 5 on, and then ultimately come up again with such intensity before Justice Lavecchia and the court in the last two opinions. Let me begin with the legal point of view. We got early on from Chief Justice Weintraub a definition of what the thorough and efficient system of free public schools means. And the definition was really quite extraordinary. In dicta, like Marbury, Chief Justice Hughes says, when a constitutional right is at issue, the court can order an appropriation. Disappears until the last Abbott decision, when Justice Lavecchia, writing narrowly, says, this is such a case. The history of this case, the recalcitrance on the part of the governor and the legislature and so forth, requires that we order that these monies be appropriated. She says it a little differently from the way I just said it, but it's actually what happens. That's also a major step in the law that happened here. And finally, what I would say, having been Attorney General and then coming to the court, recognizing and understanding what was happening, in the sense that the Department of Education, and a lot of this came out in Abbott 5, was being asked to take on responsibilities that it had never considered were within its bailiwick. How can you educate these children? How can you provide anything akin to the kind of education that Weintraub was defining when they can't even get through the day in order to learn? The commissioner came forward and said, we will have nurses that can, see what's going on with these children. The meals for children in the status of that was established for access to meals will be provided in the schools. We will set up ways of dealing with some of the extra school problems. And that was, I think, another major advance in that educational world. It doesn't surprise me that it took 46 years. When you think of the monumental changes in the way education is supposed to work, and ultimately to the efforts made in the Corzine administration to develop a real standard for how much we needed to pay for the specific kinds of needs that I'm talking about. I remember seeing photographs, Justice Stein will remember this too, of facilities, school facilities in Newark that broke my heart. In the record, there were reports about classrooms that were, where the pipes were leaking, about tiny little rooms that had been utility rooms that were being used for teaching purposes, about roof tiles falling on children's heads. The photographs were extraordinary. They were frightening. How can we send children to school in those conditions? And we were, in a lot of the Abbott districts. I think one of the major things that happened that has to be viewed as monumentally positive are that there were at least two, I know, maybe there were more, large bond issues, capital expenditures, with the priorities the court said. You must deal first with these dangerous conditions in the schools, as the report tells us, and then you must go to replace many of these facilities, many of the classrooms. It was extraordinary what we were allowing to happen in our urban areas. And I think much of that, not all of it, was taken care of. At least, I worry about this, but because I know I heard afterwards of places that they never reached. But nonetheless, I do think that was a monumental achievement that came out of Abbott. I think I'll end up with the tension between the court and the other branches. That's back to the appropriation issue. But I think it's a problem that we see whenever a court is dealing with rights issues and asking the other branches of government to make major changes in the way those branches are handling matters. And there is that tension, and maybe there will always be that tension, and that's why David and the people who follow him will always have this work, at least in part. But there's another tension too, and that's the tension out in the towns and the suburbs. And others will talk about, specific problems that New Jersey faces, the multiplicity of school districts, the local control issues, all of those things. And so you see here a court trying to deal with those tensions. You see in some administrations cooperation, attempts to follow what the court is saying. You see in other administrations philosophies that are very different from what the court is asking, and a tendency to pull back and to attempt to avoid following the court's directions. You see citizens' reactions, and when less citizens are educated, they're sitting there saying, well, my local property taxes are going up. This is crazy. It's all the court's fault, or it's all Dave Sharer's fault for bringing this litigation, or whatever it is. I think, in the end, this is such a complicated set of questions that appears in so many of these kinds of disputes that we really need to think them through. We need educated people to try to work with others they know, getting people to understand what this all means for us and why this has all happened. But we can't, I'll go back to, we cannot let children, in the first instance, go to schools where they are not safe. We cannot have many, many children in this state going to the best universities in the country and others unable to barely get through and get a high school degree, many who don't, because we're not paying attention to what's going on. And I think this is a story, and it's a story that started with Paul, and it's a story that he has been fighting his whole life. And when I think about all of these things together, I think of Paul, who is a symbol for me of what is the best and the best we can find to do.
So that was awesome. But let me follow up on one thing, just because I know you and I know how this is something that would concern you. I mean, you as Chief Justice, and even since you were forced to retire because we have that terrible rule about age 70, are concerned about the court as an institution. And as you all decided Abbott cases and worried that people like the current administration would do what they have done, which is to attack the judiciary as stepping out of its role and saying that judges were acting in doing things that elected politicians should have done. And you touched on this a little bit. Was that part of what went into the court's deliberations? If you can say, how much did that all weigh on you, and Justice Stein can talk about this as well, as you decided the Abbott cases? Because that tension is, as you said, so profound.
I don't recall, honestly, in the 10 years that I was Chief Justice, in any case where that tension existed, having a discussion. Maybe, I mean, before I came, maybe it happened. Any kind of discussion about, well, this is, going to cause problems in our relationship with the legislature. I mean, after all, it's the legislature and the governor that appropriate monies for judges' salaries. That alone might make you pause. There was never, ever, in my experience, that kind of discussion. There was a discussion about the law, how the law had been interpreted, the precedents for that, where you go with that. The court perhaps didn't go fast enough for some people. I remember Justice Stein urging us publicly in dissent to push harder and to move faster. We did have that kind of discussion. But I do not recall ever having a discussion with my colleagues that this is a problem. We did what we thought we had to do.
Were we concerned about public reaction to what we were doing? Yes, we were, but can everybody hear me? Because I'm going to use the microphone.
There you go.
We were concerned, but the press in New Jersey was marvelous. And Paul Trachtenberg told us he's going to critique us afterwards, but I'm sure he'll agree with this. The editorial pages of the Ledger and the Record, the Asbury Park Press, and every other paper supported us. My friend Alice Owen covered education for the Record. We had consistent support from the press. So were we concerned? Of course. What we were doing was enormously controversial, but the press support was critical. But let me take a step back. I grew up in Irvington, just down the street from where Paul grew up in Newark, He went to a much better high school than I did. He went to Weequahic, one of the best in the state, if not the country. I went to a mediocre high school, Irvington. But when we grew up, the best schools in New Jersey were in the cities. And to follow up on what David said before, that this Abbott and Robinson, these Abbott and Robinson cases were big deals. They were enormous. They were the biggest things that ever came before the New Jersey Supreme Court in the last 75 years, because what happened to the great city schools in New Jersey, Newark, and in Patterson, and Jersey City, and Trenton, and yes, Hamden, what happened to them is that after the Second World War, when the servicemen came back and began forming families, and builders built ranch houses in the suburbs, everybody moved out of the cities. The city's tax base was destroyed, and their ability to pay for the teachers and the resources and the public schools that had been paragons of excellence in New Jersey, for my generation, they deteriorated. And to the great shame of the state of New Jersey, because from a historical perspective, you could make a very good argument that Robinson versus Cahill and Abbott versus Burke never should have had to be filed. But they were, because legislatures and governors turned their backs on the fact that the cities couldn't fund their school districts. And they did so until Harold Ruvall filed Robinson, and Paul joined that case on behalf of the ACLU and the NAACP and litigated it literally for decades. It took from 1970 until the late 90s before our court ordered funding that was the equivalent of the wealthiest suburban school funding. We ordered that funding for the poor city. So this was a monumental undertaking. It shouldn't have been, but it was. It was in many respects bigger than Mount Laurel, because the Robinson v. Cahill court, which is the Weintraub court, was so cautious, They decided Robinson won, and then they waited and waited and waited until the court in Robinson 6 closed the public schools in New Jersey, awaiting the legislature to pass an income tax, and finally they did. And then when that law didn't work and Abbott came there, I think Abbott came to my court in my tenure probably 17 times. I got tired of seeing Paul. and it took so long, because every time we would invalidate a law, and the legislature, in the Florio administration and in the Whitman administration, would go back to the drawing board and pass a new one, they didn't work. They weren't good enough. I'll make this confession. When we decided Abbott 2 in 1992, I know Chief Justice Walensky and I had the conversation. We wanted more. We didn't want just more funding. We wanted supplemental services, and in the back of my mind in 1992 was preschool. It was something that I felt was essential for the kids in those underserved districts. They went into kindergarten handicapped. We knew it. They were 2 years behind when they got to school. So preschool was critical. And the legislature of the state of New Jersey, even though in Abbott 2, Abbott 3, Abbott 4, and Abbott 5, we ordered them to propose supplemental services like preschool, they wouldn't do it. Finally, the state, in the hearings before Judge King, volunteered to put up preschool and full-day kindergarten. But was it a struggle? It was a Herculean struggle. And thank God for Paul and for the people that followed in his footsteps at the Education Law Center for seeing it through. And yes, the funding has helped. Yes, the preschool has been terrific. It's given the kids in the urban districts a great leg up. Was race a factor? Never in the cases that came to the court was the segregation of New Jersey school districts a separate issue. Did we know that many of the children in the urban districts were minority children? Yeah, we did, but the record made before Judge LaFelt, which, as David pointed out, was such an incredible record because it showed the contrast in services and facilities available in wealthy suburbs and in poor cities. That record never told us the extent of the segregation in the schools. We knew that many of the students, that a majority of them, in fact, were minority, were black or Latino, but we didn't know the extent of the segregation, nor did we know the extent to which those minority children, back then when Abbott was before us, we didn't know the extent to which those children came from families with incomes below the poverty level. And so to make the transition, I guess what I would say, speaking to you all from today's perspective, is that while the funding improvements that the court ordered and the preschool and the kindergarten have made a difference, I think we've become aware that those districts continue to be terribly handicapped. And let me just give you a couple of numbers to give you an idea of what the handicap is. Many of you who are older may think that the issue of segregation is primarily an issue that affects the South. Well, that may have been true in the 50s, but it's not true now. New Jersey's public schools are more segregated than any state in the South or any of the border states that were subject to Brown. So 15% of our students in public schools are black. About 58,000 black students attend public schools that are more than 99% non-white. And the statistics I'm giving you come from a very wonderful study that Paul did with the UCLA Civil Rights Project. Another 47,000 black students attend schools that are more than 90% non-white. That's a total of about 105,000 black students attending schools more than 90% non-white. About 25% of our public school students are Latino. About 52,000 Latino students attend schools that are more than 99% non-white. Paul's study refers to them as apartheid schools. And another 99,000 Latino students attend schools that are more than 90% non-white. So a total of 150,000 Latino students go to schools more than 90% non-white. The extent of segregation in New Jersey public schools is simply a national disgrace. And Elise may say more about this, but I learned because of books that she told me to read that we had a checkered history back before the 40s of actual de jure segregation. Black schools being separate from white in southern communities in New Jersey. And as many of you know, New Jersey's suburbs had exclusionary housing ordinances for decades until our court intervened in Mount Laurel and ordered every growing community to provide its fair share of affordable housing. So New Jersey's segregation, which is de facto, not de jure, but it's pervasive. And the worst thing I can say about it is that no one in New Jersey government, not any governor, not the legislature, not any commissioner of education, has ever lifted a finger to try to address it. And when Larry referred to some organizational activities that are going on now, yes, there is a new organization called the New Jersey Coalition for Diverse and Inclusive Schools that's actually focused on trying to begin the process of diversifying and desegregating New Jersey public schools. It's a long, difficult, arduous process. I'm not sure I'll survive it, but in any event, it's something that we feel has to be done. But the perspective that I have is that in both respects, both school funding and school segregation, New Jersey state government should have done more. We should not have let the funding of our city schools deteriorate, and we should not have allowed, especially with the example set in the South after Brown, when communities like Charlotte and Raleigh and Louisville, and in the North like Wilmington, Delaware, have shown us that it's possible to integrate schools that have been segregated for decades. We should have done something before now, so it's high time. But the last word is the state of New Jersey owes a great debt to the Education Law Center, to David, to Marilyn Moorheiser, and to its founder, Paul Trachtenberg, for starting this massive, difficult effort to get sufficient resources into the urban public schools.
Segregation is much more than just race and income. And in the case of districts, you see that. You see race and income as the predominant forms of segregation. In charter schools, it's race and income, but it's also special needs, in that they educate significantly fewer special needs children, and the children they educate who have special needs have less severe special needs than the districts, the children who are in the districts. And then there's language proficiency. Maybe even the most severe form of segregation that we're seeing are kids who are immigrants, who are English language learners. For various reasons, charter schools have very few of those. So one of the reasons that segregation is an issue is because segregation is broader than people conceive it to be. Another reason is that the majority of New Jersey charter schools are in the cities. There are 9 cities that account for about 80 to 85%, depending on where you cut off the year of charter school students. But there are a lot of charter schools that are not in the cities, and some of the most egregiously segregated are actually not in the cities, they're in the suburbs. And, excuse me, and yeah, I think those are kind of the main reasons. So I wanted to give you some examples, because I think this surprises people. I don't know how many people here are surprised, but I think we generally bring this issue up, it surprises people. So in Hoboken, which is obviously a former Abbott, there are 3 charter schools which educate a large number of the students who live in Hoboken. And I'll give you an example of just one of those, which is OLA, which is a Spanish immersion charter school. And the district of Hoboken is about 53% low income. OLA is about 9% low income. And then looking at the suburban charter schools in Red Bank, this is one that's gotten a lot of play lately. There is a small school district and a charter school, which draws exclusively on that school district. And the district is about 90% low income as defined by free and reduced lunch. The charter school is about 41%, so less than half. The district is 31% English language learners. It's got a very high population of immigrants. The charter school is 4%. The district is 81% Latino. The charter school is 39%. And the district is 7% white, and the charter school is 50%, and it's been about 50% for 20 years, roughly, that it's been in existence. So it's a persistent pattern of segregation.
First, I just want to say to Paul, who is my mentor and also my friend, but also a warrior for justice. The report that Justice STEIN referred to, which I have, it's dog-eared and tabbed, and I've highlighted, and it's sort of the such an important document for laying out the extent of segregation in New Jersey public schools. And when I say that Paul is a warrior for justice, he is so passionate. And so the title of the report, it's not just segregation in New Jersey schools. It's New Jersey's apartheid and intensely segregated urban schools, powerful evidence of an inefficient, unconstitutional state education system. All you need to know is right in the title of the report. But I want to just go back for a moment to sort of an irony of my own work and how Paul educated me. So Larry mentioned that I was at the NAACP Legal Defense Fund as a director of litigation, but before that I was a staff attorney, and I litigated desegregation cases in the South, in Alabama, a little bit in Arkansas. And I like to say that, and some of you have probably heard me say this, that it's easier to talk about race in Alabama than it is to talk about race in New Jersey, because we don't have a race problem in New Jersey. We don't talk about it. And I spent all this time on the road, and I lived in New Jersey for 20 years, but when I came to Rutgers, this was the first time that I had actually worked in the state where I lived. And part of what Paul hit me to is that we got a lot of segregation in the state of New Jersey. New Jersey is the 5th most segregated state in the entire country. As Justice Stein mentioned, it is far more segregated than Alabama, Arkansas, districts throughout the South. Far more segregated. The other 4, by the way, are Michigan, Illinois, Maryland, and New York. All states in the North. And you ask the question, why is that? And I think part of the reason why that is, one is race is a hard issue. When you raise it, people don't want to talk about it. They run from it. But the other thing is, and it goes to the point that Justice Stein made, which is that for a lot of people, it's invisible, segregation. We just happen to live in neighborhoods that are predominantly white or predominantly Black and Latino. There's no Bull Connor or Jim Clark, no Birmingham, no Selma, no fire hoses, no dogs. There's no evil actor that you can point to and say, that person is doing something bad to people of color. What we have is an architecture of segregation that is the product of a long, long history of zoning and housing decisions, and it's complicated. But it's because it's the context within which people make decisions, and we don't see it, right? We have it's sort of like if you're in a bowl and you've got certain choices, right? You're just going to pick the choices that are in that bowl. You're conditioned only to see the options that are right in front of you. And so the problem is we don't see it. And we have this also, we know from federal constitutional law, we have the distinction between de jure and de facto segregation. And I've spent a lot of time, more time than I would like actually, in the last couple of weeks, reading about quote unquote de facto segregation in the North. And as it turns out, de facto is not quite so de facto. Because as a factual matter, there are a lot of places in the North, and I have to guess that New Jersey is among them, where state and local governments work very, very hard to keep schools from being integrated. They altered attendance zones. They sited schools very, very strategically in ways that tracked neighborhood boundaries. They had neighborhood policies, neighborhood school policies, so you had to go to school in the neighborhoods where you lived. That was by state law. right? There are transfer policies, there are freedom of choice problems. You have this very, very arcane network of policies and laws that conspire to keep Black and Latino kids separate from white kids. And then we have on top of it, in New Jersey, there are 600 some odd school districts. We have these teeny tiny little fiefdoms all over the state, right? And a powerful, powerful history of local control. People value local control very intensely in this state. So we have this incredible problem that people they're just not conditioned to see it because it's not in front of them. It's too subtle. But I want to say a little bit about why it's such an important issue, and I think why we need to focus our attention on it. And it has to do with the notion of the problem of what some people have called, and Paul, I may even have gotten this from Paul, we're not really conditioned to care about other people's children. We're conditioned to care about our own children, right? So we want to make sure our own children have quality education, right? Access to top-notch instructors and the like. And we've created this architecture in New Jersey, in which that idea is very racialized because of the intense segregation, right? So it's like, if you think about a sports analogy, you've got two teams, right? If your kid plays on the team, you want to make sure that team wins. So you're going to make sure that every child on that team has what they need. They're going to have the right uniforms, they're going to have the right coach, they're going to have the right instruction, they're going to have the right facilities, right? You're rooting for that team. But we're on separate teams in this state. We have our schools are very heavily racialized. When you map race onto that separateness, you're conditioned to think of people as being different, right? Those kids are different. Those parents don't value what I value. And the problem that creates is something that the former head of LDF, John Payton, used to say about democracy. The problem with segregation is that it undermines our democracy because we don't see people as peers. If I don't interact with you, if I don't have to talk with you, if I don't have to have a conversation with you, if you're always over there, right? It's very easy to think of people who are always over there as different, as not similar to me, as not wanting what I want. And what integration creates is that opportunity for people to experience one another as peers. And the health of our democracy depends on it. And so the problem that we face in this state is very, very serious. And I want to go back to, I think it was Chief Justice Porritt said, right, the best way to honor Paul, because Paul has done yeoman's work in this area with the research that he's done on the Morristown School District, right? He has made this issue part of his life's work. And the best way to honor Paul is to take on that issue and to take on that mantle. And Paul, I just want to thank you because you're a kick-ass.